Well, welcome everyone, and thank you so much for joining us today for our panel on the legal needs of early stage startups. I'm Kirsten Loita of Osage University Partners, and I head up our university relations efforts here at OUP. I'll be the moderator for our discussion today. Thank you, Brittany, for changing the slide. I'm really happy to be joined by four excellent panelists today, all of which have a certain topic that they'll be talking about, and I'm going to have them each first introduce themselves right now. So, Brian, could you introduce yourself first?
Yeah, absolutely. Hey, everybody. I'm Brian Apple. I'm a corporate partner at Wilson Sonsini. Been an attorney for about 20 years, last 10 of those at Wilson. I work primarily with life sciences startups, some tech startups as well, on the corporate side. And we work with companies throughout the full life cycle, getting them formed and organized, which is what I'm going to talk about today, and then helping with financing, growth, and eventually exit those entities.
Great. Thanks. So glad you're here today with us, Brian. Tali.
Hi, everybody. Thank you so much. My name is Tali Tuchin. I am a partner at Mint, and my practice is in licensing and technology-based transactions. I've also been doing this for a little over 20 years. I spent some time in-house at Invitrogen Life Technologies and really learned the science there. And I advise clients primarily in the life science space on all stages of life cycle from formation to exit and all of their contracts and agreements and licenses in between.
Great. Thank you, Tali. Mark.
Good morning, good afternoon, everybody. Mark Morley. I'm a partner with Mintz as well, along with Tolly. I'm an intellectual property attorney, primarily practicing in patents in the life science space, ranging from biotechnology, pharma, to medical devices. I've been in practice for over 25 years, and I work with all types, ranging from startups coming out of universities or otherwise to pre not private companies, public companies, and everything kind of in between. So it's nice to meet with everybody here.
Great. We're so glad you joined us as well, Mark. Matthew.
Hey everyone, I'm Matthew Brown. I'm a senior member of the Life Sciences Business Advisory practice at Wilson Sonsini, based out of our San Diego office. My practice is advising early stage life sciences founders on how to raise capital. I work on things like investor pitch decks, investment thesis and narrative, investor targeting and outreach, fundraising strategy, and general business development topics. It's a pleasure to be here.
So glad to have all of you with us today. As people have probably noted, we have more presenters on than we usually do on our webinars. Because of that, we have a very huge topic to talk about today. This webinar is scheduled for 90 minutes rather than our usual 60 to 75. So the first hour of this particular webinar is going to be presentations by our fantastic experts here, and that'll be followed by half an hour of Q&A. We'll go to the next slide. Before we dive into our discussion, just a few logistics. A recording of this webinar will be available on OUP's partner portal afterwards, and we'll also be sending out the link to that, as well as the link to the YouTube channel, where the recording will also be posted. For those of you who are at our partner institutions, so academic partner institutions, you have access to our partner portal that I mentioned. It's an online portal for tech transfer officers and researchers at those partner institutions. It's full of relevant tech transfer and startup content. And there's information here about how to get to the partner portal if you are at one of our partner institutions. But as I mentioned, the presentation will also be available on our YouTube channel, and we will be sending out copies of the slides to everyone who registered for this webinar as well. So look for a follow-up email with links. Actually, not later this week. It says later this week. That's usually what we're able to do, but it's going to be next week that we'll be sending this out to everyone this time. We do have some other upcoming webinars that may be of interest to our audience as well. We have 3 of those scheduled right now on May 14th. We have early stage investment instruments in startups, SAFEs and convertible notes. Very happy to be joined by Adam Sterling and Manny Stockman for that particular webinar. Then on June 3rd, we'll have an event webinar exploring venture debt, a strategic option for startup growth. We have presenters from Western Alliance Bank and Bank of California joining us for that one. And then on August 19th, we will have a webinar focused on advisory boards for academic innovation operations and how those work in practice and how useful they are for innovation operations at academic institutions. So with that, We will go to the next slide, just an overview of OUP. For those of you who don't know us, we are a venture capital fund that partners with academic institutions to invest in their startups, typically by exercising participation rights available through their licenses. For those of you who don't know what a participation right is, they are the ability to invest in future rounds of a company on the same terms and conditions as other investors. We do have recommended language on participation rights for those who do not currently have those in those license agreements, or if they have any questions on that, please let us know. As part of our partnership with academic institutions, we share a portion of our profits with them, and they also receive programmatic support on tech transfer and academic startups. We're now on our fourth fund here at OUP, and we've made investments in over 150 different companies in all areas of deep sciences. And if we go to the next slide, it just shows an overview of the types of companies that we've invested in before. It's not a full overview of our portfolio, but we're always happy to tell people about our model and how we work with academic institutions and the startups coming out of theirs. But with that, we are going to go to the next slide and get more towards our agenda of the day. These are the four main areas we will be talking about from each of our presenters, as you've probably gathered from their intros. But I do want to just ask a few questions of our panelists before we get going, so that there's a kind of context for why it is we're talking about these particular areas. So when a startup is first being conceived, there are certain areas for which the founders need to hire attorneys to help them because they don't have expertise themselves to do it, and there are certain legal needs that they need covered. So we are covering four of those main areas, and I wanted to talk with our panelists a little bit about first how they typically meet the entrepreneur founders that they work with. And Tali, I'll put this to you first, and then Brian.
Yeah, so oftentimes I meet founders through word of mouth, just through the network of other founders who have worked with me and maybe recommended them to their peers and friends. I also try to get out into the community fairly regularly by attending networking events, professional development events. I connect with organizations like Nucleate here in San Diego out of UC San Diego. I connect with Biocom, which is down here in Southern California. I participate and sponsor lots of women in bio events. So I try to get out there in the community as much as possible to meet founders. And I would say that when you, as a founder or somebody who's looking for connections to an attorney, of course, word of mouth and personal recommendations and referrals are great. But also know that we should be kind of filtering out there in the community as well at these events.
Tali, thanks. Brian, same question.
Yeah, in similar response, a lot of folks come in through our network. We're kind of a very established firm in the space, so we get a lot of referrals, and we're also out in the community, and we meet folks at universities at various events. For example, we're a sponsor of Stanford's biodesign program on the med device side, so we get a lot of clients in through that way. And we honestly give a lot of these talks at various different universities hosted by their tech transfer offices. So we meet startups that way, but a variety of different ways from kind of being out in the community.
Great, thanks. So, there are potentially a lot of attorney firms out there that people can work with. And I'm going to ask this next question of Matthew and Mark, and there's kind of two parts to this question. So one is, do you find that entrepreneurs sometimes mix and match their attorney firms? And then how do you and they kind of know they've found the right fit, perhaps for their attorney needs? And Mark, I'll start with you.
Yeah, so on the question of mixing and matching, we do find that quite a bit where, for example, in my case, where I'm handling an intellectual property for a client and maybe somebody else is handling the corporate work or other types of work, regulatory work, and those kinds of things. So it is common. It's also not uncommon to have the same firm handling both as well on the front end. So I don't think there's necessarily a perfect approach. There's pros and cons to each. Sometimes having that one common firm can be helpful, but I would say I think the relationships with your professionals are super important. So making sure you are comfortable with the person or persons that you are working with is is what I would focus on, making sure you feel like they hear you and they understand your vision and kind of what you're looking to do, and you have a good relationship with them, I think is most critical in my view.
Thanks, Matthew.
Yeah, I'd say this is an interesting one for me because my practice is somewhat unique. I'm a lawyer, but practicing within Wilson sort of in a non-legal capacity. If you're interested in my service offering, we're the only shop that you can really go to aside from an investment bank or a boutique consulting firm. So that's kind of an easy one for me. I'm unique and kind of differentiated in a way. But I really like being able to work with colleagues like Brian inside the firm and that sort of hand in glove fit that we're able to work on the fundraising. And if we're successful, then that naturally flows into Brian helping to paper those financing transactions and the like. So there's a real benefit to having one firm, but I certainly see fairly regularly folks that have a number of different counsel representing different aspects of the business.
Great. Thank you, Matthew. So last question before we get into the slides themselves. Why are each of these areas, the ones that we're talking about today, why are these the most pressing areas that a startup may need to work with an attorney firm early on in their journey? Brian will talk first about incorporation.
Yeah, so as I'll get into in my presentation, it's important to kind of establish the right legal and corporate foundation as the repository for all of your ideas and hopes and dreams. So it doesn't become an issue going forward in diligence with investors and acquirers. And I'll kind of get into the nuts and bolts of that, but it is important to get it set up the right way on the corporate side.
Right. Mark, IP.
Yeah, IP is your property, as the name would suggest. It is the property that you can sell, that you can license. It is the thing that will allow you to have exclusivity and prevent others potentially from being in your space. So it's the piece of property that gives a lot of the value that investors are going to want to see before they're going to put their money into your idea, your company. And I'll touch on these a bit more during my time.
Perfect. Tally, transactions and licensing.
So your license agreements from the very first one that you take from the university is basically the foundation of your operations and the springboard for your innovation, and the building blocks of the actual technology that you'll use to innovate.
Great. Thanks, Tally. And Matthew, fundraising and Dex.
Yeah, I would say all of the topics you're going to hear about from my panelists are important, but no company gets very far without capital to be able to execute on their programs, and especially for first time founders, fundraising is an extremely complicated process, and you're dealing with stakeholders whose motivations are very, very different from yours. And having an advisor that can walk alongside you and help navigate that process is extremely valuable and can make a very complicated, protracted process go much smoother so you can get back to focusing on executing on your development programs.
Great. Well, thank you all for answering those questions and kind of setting the stage for why it is that we're talking about these particular 4 topics today. And we're going to talk about what each of these means now. And I am going to mention that we had a lot of questions come into us beforehand from our panelists, from our registrants. And we will be addressing those. A number of those involve costs as well. So we will be talking about costs in the future. But now I'm going to pass it over to Brian to talk about forming and organizing the startup entity.
Great. Thanks, Kirsten. So hey, everybody. I'm going to talk through kind of, like I said, establishing the corporate foundation for your venture. I'm going to talk about which form of business entity to choose or which form most companies choose, where to incorporate, and then kind of what to do once it's set up, how to issue yourself and others equity, and some other considerations. The win kind of revolves around, whether you're ready to take a license from the university. Most kind of academic founders are, into that process. It takes a little while. And kind of at the end of it, you're going to need a business entity to kind of be the repository for the license. So that's often kind of the time at which university founders approach us. Um, and I guess the three common legal organizations for the type of startups are the limited liability company, the S corporation, and the C corporation. And just to kind of skip to the end here, 99% of the companies that we form for our startup clients at Wilson are Delaware C corporations. And that's because most of our companies are venture backed or have aspirations to be venture backed. And it's that type of entity that venture capital firms are, able to invest in and most comfortable investing in. But to just go through the other two first, next slide, please, Brittany. The limited liability company is a relatively flexible vehicle. The important thing to remember about the LLC is that it is a pass-through entity for tax purposes, meaning that there's no entity level taxation. When you have income, when you have losses, those pass through the entity directly to its owner's individual tax returns, which is a benefit on one side. It makes it problematic for venture funds because they don't want the pass-through tax attributes because it results in what's called unrelated business income tax. And since venture funds are set up as partnerships, they're pass-through entities themselves, it passes through to their limited partners, often, university funds, pension funds, and so on, who don't want to deal with that unrelated business income tax. So they often cannot invest. Often their fund documents are set up so they can't invest in pass-through entities, which means LLCs and S corps, which we're going to talk about next. Some founders do choose to set up an LLC anyway, and you can convert it to a C corporation later when you're ready to take venture funding. That process can be relatively streamlined or it can be complicated, kind of depending on how far you are down the road. But it's something you'd want to talk about with your counsel and with your accountants at the time. Next slide, please. So the S corporation is also a pass-through entity for tax purposes, which again makes it problematic for VCs. It's also limited in terms of the type of shareholders and the number of shareholders that you can have. You can only have individual shareholders rather than entities. So it's a problem for basically any entity investor like a VC. And you can only issue one class of stock, meaning you can only issue common stock rather than the preferred stock that venture funds are going to want to invest in, which has a bunch of rights and preferences, a bunch of bells and whistles that common stock issued to founders for compensatory purposes does not. So the S corporation is basically a C corporation. It's just made a filing with the IRS to elect to be an S corporation and get this pass-through treatment. So you could start out with an S corporation and then sort of below that election with the IRS and issue preferred stock to VCs. The problem is that you won't be eligible to receive what's called qualified small business stock, QSBS, which I'll talk about in a couple slides. Next slide, please. So the C corporation is the default vehicle for most venture-backed startups. The governance is pretty simple. The stockholders or owners elect the board of directors. The board kind of oversees the strategic direction and long-term planning of the entity and appoints officers that manage the day-to-day affairs of the company. Like I said, VCs can invest in it. It can issue preferred stock in multiple classes, unlimited number of stockholders. Crucially, employees and consultants can understand the stock incentives, which is not always the case with an LLC. Stock options, which I'm going to talk about later in the presentation, are generally well understood by folks in the industry. And from a kind of taxation standpoint, it's a separate taxable entity and it's eligible to issue what's called qualified small business stock. Next slide, please. So QSBS gives founders the ability, once they sell their shares, once the company is sold, several years down the line, they can exclude 100% of their federal taxes, their taxable gain, up to the greater of $15 million or 10 times their basis or what they paid for the shares. So potentially a very large federal tax benefit. And it's matched in most states, not California, which likes to hang on to your tax dollars. But in most other states, there's a matching state level exclusion. So it could potentially be a very valuable benefit. And it's been changed a little bit in the last year here under the recent changes to tax law, such that you no longer need to hold it for 5 years to get the benefit of the exclusion. You can get 50% of your capital gains excluded if you hold the stock for 3 years, and then 75% after 4 years. And if you hold for 5 years, which most founders do, to be honest, then you get the full 100% exclusion. So only C corporations can issue qualified small business stock. If you convert an LLC upon the conversion date, they can issue qualified small business stock. S corporations cannot issue it, and there's no good way to get around it. So if you start out with an S corporation, you're giving up the QSBS benefit. So something to keep in mind. Next slide, please. And then where to incorporate. Most of our companies default to Delaware. It has specialized business courts called the Court of Chancery. They have deep 100 years of precedent and predictable outcomes for founders and investors. The costs are relatively low. There are registered agents kind of there to make filings for you in Delaware. You don't have to be physically present. You can be in any state in the country or anywhere in the world to have a Delaware corporation. And it works best for IPOs and reincorporation. So other states have become popular recently. You may have heard in the news that Elon kind of famously took Tesla out of Delaware into Texas because he was unhappy with a Delaware court result regarding his compensation. There have been other kind of high-profile moves to other states like Texas and Nevada. We still think that Delaware is probably the best in terms of the best place to incorporate a company. VCs seem to feel that way, generally speaking, as well, with a few notable exceptions. So Delaware is generally the place where we advise folks to start out. Next slide, please. So once you're set up, once you're formally incorporated, you need to issue yourself founder stock and get certain other documents set up. We'll talk about that next. Next slide here, please. So you're going to set up the company with a set of incorporation documents. You'll file a certificate of incorporation in Delaware. You'll adopt bylaws, which are kind of the rules of the road for the company. You'll sign incorporating organizational resolutions for all of that. And then we're going to get stock issued to you through founder documents, and we're going to get your IP assigned in through an invention assignment agreement. And then we'll talk about the next couple buckets, the employee documents, and you'll want to have consulting agreements and NDAs ready to go so you can hire consultants and go out and share your confidential information with third parties in the market. Next slide, please. So this one, it looks like it didn't really come through, but your incorporation documents are the ones that I just talked about, your certificate of incorporation, your bylaws, your organizational resolutions. Your first board actions will establish the board of directors, appoint officers, it's usually you, issue founder stock, kind of authorize the issuance of the founder stock. You're going to adopt a stock plan or an incentive option plan to issue stock to employees and other service providers, and then it'll handle other administrative matters. Next slide, please. So founder documents. So there's a couple tracks here. There's making sure that the IP and confidentiality is locked down, and then there's getting you your equity in the entity. So on the IP side, you'll have an invention assignment agreement that basically assigns in everything that you work on that's related to the company into the company so it's owned. And that's something that investors are going to be particularly interested in going forward, There are certain considerations there when it comes to university founders who have pre-existing kind of IP assignment obligations to your institutions, and that's something to talk through with your attorney. And then issuing founder stock. So typically founders and startups and C corporations get what's called restricted stock. So you get to buy all of your stock at generally a very low price. Since you've just formed this entity, you take the position that, even if it's getting a university license, the company has relatively little value, right? So you're purchasing shares for a fraction of a penny per share, which we call par value. And then value accrues over time. Typically, and especially if you have multiple founders in an entity, you want to apply vesting to your shares. The typical vesting is over 4 years with what's called a 1-year cliff, where there's no vesting for the first year and then 25% vests on the first anniversary. And then you have the 1/48th kind of monthly vesting after that. You can negotiate for acceleration provisions, single trigger versus double trigger. That's something kind of to talk about with your attorney to protect you in the event of a change of control of the company during your vesting period while your shares are still unvested. And very important when you're receiving restricted stock like this, that's subject to a repurchase right if you were to leave the entity while your stock is unvested. Very important for you to file what's called an 83B election within 30 days of the date of your purchase with IRS. That clock can't be reset, can't be extended, and it basically advances all of the tax consequences of buying the shares to the date of purchase. If you don't file it, you're taxed on the delta between the purchase price, which is effectively zero, and whatever the fair market value of the stock is at the time it vests. So in a startup company where the value is increasing rapidly, hopefully, that could be a significant sum, and it could be a big tax hit to you. And there's withholding obligations for the company. So it can be a mess if the 83B isn't filed. So just something to keep in mind. Second group of documents here are the employee documents. So you'll have an offer letter that you send to employees and an invention assignment, generally the same one that founders sign. It's going to be required for every employee and every consultant. And then you're usually compensating those service providers with an option grant. And you'll issue an option under the stock plan that we talked about. And the option has to be issued at fair market value. And sometimes that's determined through an independent 409A valuation, it's called. And each option grant, importantly, needs to be approved by the board with proper paperwork and proper dating. So next we'll talk about options here and pricing common stock. Next slide, please. So as I said, options need to be issued at fair market value. That's a requirement under the tax code. And Section 409A of the tax code provides a safe harbor. Basically, it says the IRS won't come after you for issuing cheap stock if you're relying on an independent valuation from a valuation firm that establishes the fair market value of the common stock. So that's called a 409A valuation. So typically speaking, companies don't go out and get those independent valuations until they have institutional capital represented on the cap table. At the outset, at incorporation, we usually take the position, boards can establish the fair market value. We take the position that your fair market value is fairly low. And you use that to grant options. But fair market value will move when you do, a fundraising. That's a material value inflection point for companies, of course. It doesn't apply usually to safes and convertible note financings. But after that, after you raise money, you want to get a 409A valuation every 12 months. Next slide, please. So the grant process, this is something you'll just want to coordinate with your attorneys on, making sure that grants are appropriately approved, that folks are eligible, they're current service providers to the company, and then everything kind of works under the stock plan. This is one area where we do see companies cut corners. It becomes expensive to talk with your attorneys all the time about these things. So people try to do it on their own, and this is where we often see mistakes made. and cleanup here is costly. And all of these things come to light when you do a financing. Investors have attorneys too. They're looking through a data room. They're looking through all your documents, and we have to clean things up. And that can be more expensive than kind of the initial cost if we would have done it the right way. Next slide, please. So in terms of issuing options, employees are eligible to receive what are called incentive stock options. Those have special tax benefits for employees. Everybody else receives NSOs or non-statutory stock options. And the difference there is that there's no tax on either of these when the option is granted. For the ISO, there's no tax when an employee actually purchases the shares underlying the option, unless an alternative minimum tax adjustment applies. For consultants and other folks, there is tax that's payable upon exercise based on the spread. And then there's tax for everybody at sale, generally at long-term cap gains rates, as long as you've held the shares, as long as you've exercised at least a year prior to the sale of the company. Next slide, please. So I'll wrap it up here. We've got a lot of stuff to cover, limited time. So we covered kind of the entity choice here and issuing equity to yourself. I think important thing, takeaway for me is, try to get this right the first time, work with an attorney to get the foundation right. And this is an area where you don't have to be particularly creative. Like just do it the normal way that everybody else does it. Take all of your creative energy and put that into developing your technology, and just kind of leave the corporate foundation kind of in a uniform structure. So that's me. I'll turn it back over to Kirsten. Thanks.
Great. Thanks so much, Brian. We have a few questions here. I'm going to save the ones on LLCs actually till the end. And I would actually encourage people to please put your questions in the Q&A tool rather than the chat, please. It's much easier for me to track. But one quick question for you, Brian. How is QSBS handled for investors who start with safe notes that don't convert until the acquisition or exit? In other words, the startup didn't actually have a priced financing round until the acquisition or exit, so the safe notes didn't convert until the acquisition.
Yeah, good question. So in that case, there would be no QSBS issued. When in kind of a normal track where a safe or a convertible note converts into the next equity financing, investors will often tack back to the original date of their safe or note investment for purposes of the QSBS 5-year holding period. But if folks have not converted their safe or convertible note, and the company sells, there's no QSBS that was ever issued, so they don't get the benefit.
Makes sense. All right. Thanks, Brian. Mark, we will pass it over to you.
Thank you, Kirsten. Well, my obligation here, consistent with the meeting agenda here, is to cover finding the right attorney partner to work with you on the following items. What kind of IP should you pursue, if any? Timing of when to file patent applications, understanding the patent process and patent costs, and also understanding obligations to the university and filing IP for your startup. So I'll try to cover those in the next 10 to 15 minutes here for everybody, and then be available to answer questions. So there are various types of intellectual property. We're going to focus on patents here, which are the primary type of IP that startups should be most interested in. There's other types of IP, trademarks, copyrights, which usually aren't quite as relevant, although they could be. And with that, I would say just one take-home message is do not be afraid to reach out to IP attorneys as early as you can. Most of us are more than happy to triage your situation early on, even off the clock, so to speak, just to kind of help point you in the right direction, help you identify considerations and things you should be thinking about on the front end before problems arise and before you have serious time considerations that are going to make it difficult for you. So don't hesitate to reach out to your tech transfer office, to IP attorneys, and talk through some of these things on an appropriate level of detail early on in the process. It'll save you a lot of heartache and headache later on, potentially. But focusing on patents, just with a diverse group here, wanted to first just touch a little bit on what is a patent. In the United States, patents are actually one of the few forms of intellectual property, one of the few countries where patents are specified in the United States Constitution. And the Constitution says that you can secure for a limited time to inventors exclusivity, a monopoly right in their intellectual property. Congress has deemed that in the case of patents, that monopoly right is 20 years from the earliest non-provisional priority date. For some types of technologies, it can take quite a bit of time to get your product approved. For example, in the case of things that need FDA regulatory review or other types of review, those delays can allow you to add some time onto your patent on the back end if you spend a significant period of time working your technology through a regulatory process. But generally, the rule is 20 years from your earliest non-provisional priority date, which I'll touch on here in a few minutes as well. Upon expiration of your patent, the subject matter is in the public domain and others are free to practice it. And hopefully the purpose of patents is to provide an incentive for innovation and to allow others to build on the good work that original innovators have done. So that's a little bit of quick patent basic. Next slide, please. A couple of just things to be aware of in terms of what is patentable in terms of a discovery or an improvement. There's kind of three big categories here, which I'll just mention briefly because they'll play into some of the timing considerations that we'll hit on in a few minutes here. Number one, your technology must be novel, meaning nobody has done the same thing previously. All of the elements of what you ultimately want to claim in your patent cannot be found in a single public or prior art location, a publication, a paper, or somebody else's patent. So it has to be novel. Nobody's done the same thing before. Even if it's novel, it also must be non-obvious or adequately inventive to justify the granting of this monopoly right. So that's a very subjective inquiry, whether something is an adequate inventive step, inventive advancement over the prior art, even if it is novel, but it has to be non-obvious. And then finally, there's a requirement for a quid pro quo or a disclosure requirement. In order to be given a patent monopoly on a technology, you have to put the public in possession of your invention so the public can practice it when it's available. So you can't kind of get a patent and hide the ball. You have to provide adequate detail to educate the public on it. Next slide, please. So before I get into timing considerations, we'll stay on this slide for a second. Just what kinds of things can you patent? And maybe when would you consider not getting a patent on something? So there are different categories, but just to kind of list a few, you can get a patent on any device, any apparatus, any what I'll call compositions of matter, which compositions of matter might be things like, in the case of biotechnology and pharma, it could be chemicals, potential drugs, antibodies, big molecules, small molecules, recombinant cells, viral technologies, and all various other types of compositions, whether they're therapeutic or not. Those are compositions of matter. So devices and apparatuses, machines, compositions of matter, methods of doing things. That this can be everything ranging from methods of treating an illness to methods of performing a function that might be done on a computer or a machine or an AI type of technology, for example. And then another category would be methods of making something or manufacturing it. So all those things are often eligible for patent protection. And sometimes you'll have, especially in the case of methods of making or manufacturing, you may have things that you might want to consider keeping as a trade secret. And there's the main consideration there for trade secrets is, can you keep it a secret? Number one, and number two, even if you can keep it a secret, is the industry moving hot on your heels such that others might come upon the same invention or trade secret soon? And in the case, if you can't keep it secret or others are coming up in this, it's a hot space where others are going to get there, then a patent probably makes sense to consider. So with that, let's turn to timing considerations. You have an invention and a technology. Now what? As I mentioned, don't hesitate to reach out early and often to talk to your tech transfer team, your legal department, or your patent attorneys of choice to understand these timing considerations and make sure you're doing everything you can to time your filings appropriately. And in a minute here, I'll hit on a timeline to kind of illustrate this. One other thing is you've got to keep your invention confidential. It's the minute you share your technology in a non-confidential setting, you very well have given away rights or jeopardized your rights, mostly in foreign jurisdictions. The United States gives you a 1 year clock to file even after a public disclosure, but many significant foreign jurisdictions do not. So the second you publicize or talk about give a paper, publish a paper, a presentation outside of confidentiality, you may have just jeopardized your rights. So be very cautious in not talking about your technology in a non-confidential setting. Disclosure under NDAs or CDAs is okay. It's always preferred to file a patent even before you do that. When do you file? Nowadays, around the world, the rights go to the first to file a patent application. So you're in a race to the patent office at this point, but you have to balance that first to file desire with, do you have enough data and enough development to support this patent? And I'll talk about some timing considerations with that in a slide here in a minute or two. And you should consider whether to file prior to any non-confidential meetings or even confidential meetings where you might be worried about the other party taking what you've done and trying to act on it or play with it. So again, file prior to publication, seminars, or any public disclosure. Next slide, please. So this is just a timeline process here that I thought would be helpful. On the left, you can see you start out with development and optimization of an invention. And at some point, you're going to want to file typically a provisional patent application is what I usually recommend. You can file a non-provisional, but there's some real benefits to a provisional application. One being that it isn't your non-provisional that triggers your 20-year clock. So you actually can get 21 years if you take advantage of a provisional, which can be very helpful in the life sciences and industries where the back end of the patent life is really valuable and important. Number two, if you've got a technology, whether it's a device or a medical therapeutic technology that's in development, you can file a provisional on your kind of initial iteration, and you then have 12 months before you have to file your non-provisional. And during that 12 months, you can supplement and file additional provisional applications with improvements. You might, in the case of a medical device, for example, file an initial application during the prototyping process or developing the process of how you're going to manufacture it, come up with some improvements that make it easier to manufacture, better to manufacture, or just make it better. That in that 12-month period, you can supplement your original filing. And then at the 1 year date, when you file your non-provisional, you can file your best and latest application that's really more ready for prime time. So that's a key thing. So often I encourage people to balance racing to the patent office with how much can you have 12 months after your first filing. That can be pretty important and pretty critical to think those things through and how much data you can have at 12 months. The other timeline here is 1.5 years from your original filing, whether that's a provisional or a non-provisional, your patent application will publish. So that's another timeline. How much development work can you have done before publication? Because once your application publishes, number one, the public will be aware of it. Number two, your own publication will then be prior art against your own downstream innovation and development work. So the more you can do before 1 year and before 1.5 years in filing patent applications, it will make life much easier on you going forward. It can be difficult as a startup sometimes because you have limited resources, but again, that's why you can talk to a patent professional and really set a plan for how you're going to maximize resources with your ability to file patents. Let's go. Some of these other things we won't touch on here, but for budgeting purposes, 2.5 years from your first filing is when you'll have to have a significant budget to file in foreign countries. So that's something to keep in mind. Once your patent issues, which is usually 3 to 7 years after your first filing, then you may have some maintenance fees and annuity fees to keep track of. So next slide, please. So the final thing I want to hit on here for just the next 2 minutes is some ownership considerations and obligations. As Brian mentioned, when you're trying to raise money, when you have investors looking at it, they're going to be very concerned with who owns this invention. Do you have ownership properly tied up? Ownership naturally flows to the inventors of an invention. However, most companies and most universities, and Brian just talked about how you'll have agreements where anything you, as an employee, you sign obligating you that anything you invent as a part of a university or a company, often you've contracted that away to the university or your company, and they actually own it. But it's important as a startup company to make sure you have those agreements, to make sure you understand your obligations to your university, so you know what rights the university has, and that you can understand going forward who the inventors will be and what their obligations will be to know who owns what. And Tali will talk about how you can tie those rights up through licenses and assignments. But so be aware of employee agreements, university IP rights agreements, other corporate documents, and you'll want to have things cleaned up with the rights to your inventions properly assigned to the proper entity. You'll want to make sure you have license agreements for anything that is owned by a university that you want to have in your new company. And then it's also important, I kind of skipped this up above, to identify who your inventors are. You do not want to leave off an inventor. You do not want to include somebody that shouldn't be an inventor. Those can be grounds for your patent being unenforceable. So make sure that you are honest in who your inventors are. And anybody who's an inventor or a co-inventor on a single claim will have rights to the entire patent. So you want to be very cautious and careful to make sure you identify all inventors and that their rights are tied up with the university or entity so that you can have full ownership of anything that comes out of it. So that is it for my initial presentation.
Terrific. We'll ask a couple quick questions to you too, Mark, before we go on to Tali. Trade secrets. What do you do on those? How do you protect them? Someone asked, do you register them? So just quickly mention trade secrets.
Yeah, good questions. Yeah, there's no real registration process in the US for trade secrets. It's often you will identify them just for your own sake, and investors will often ask, what are your trade secrets? But it's anything that know-how that you have, how you make something, how you do something that isn't covered by a patent application will be considered a trade secret. Keeping them secret, you want to have, and Brian and Tali can hit on this as well, you want to have agreements. Brian mentioned confidentiality agreements, and there are other types. You'll see trade secret provisions often in your employment agreements that will mandate that employees keep things confidential, what they can and cannot take with them when they leave. All of that goes towards that high overarching concept of you can keep it a trade secret as long as you can keep it a secret. And so you want to take reasonable measures to keep it a secret through agreements, document retention policies, and so forth. Coca-Cola is the famous trade secret. It's a trade secret still because they've kept it a secret and others haven't been able to recreate it adequately. So it's a powerful trade secret. But as long as you can keep it a secret, it can be a very powerful right. Balanced, as I said earlier, with if you're in a hot area where others are likely to come upon that same secret, then you may want to forego a trade secret and go with a patent.
Great. Thank you so much, Mark. We have a lot more questions, but we're going to move on to Tali, and we'll get to those questions later in our Q&A session.
Okay, yes. So my topic is licensing with the view that we're talking about early stage companies. And so much of my discussion will assume that we are licensing technology from a university, which is such a common way to begin the foundation of your company's technology. Slide. So what is a license? A license really is just permission. It's basically getting permission from the owner of intellectual property rights. So we just talked about patents. The same can be true for trade secrets. Permission to practice that technology, practice that invention without infringing the patent right. And it's accomplished through a legal contract. So a license agreement is a contract. And licenses are permission to practice various types of IP. So we talked about patents, trade secrets. Software is a work of authorship that is protected by copyright. So you can take a license to software or to other works of authorship. You can take a license to data. Data is extremely valuable and more important in our day and age. And so companies and research institutions and everybody is taking a much more kind of proactive view on protecting data and allowing data to be used only under certain conditions, usually in exchange for some consideration. Slide. So many life science startups are not necessarily coming up with their initial invention or innovation on their own in their own personal lab. Much of the technology is coming out of research institutions. And these research institutions, including academic hospitals and universities and other nonprofits, very often have some sort of office that manages and controls the intellectual property that's being protected by the institution, including to grant licenses. And oftentimes that's called the Tech Transfer Office or Technology Management Office. They have different names. And part of the mission of these tech transfer offices is to carry out the mission of the research institution, which is very often to put inventions, new inventions, and new innovations into the hands of the public. So how do they do that? The Tech Transfer Office is empowered to allow commercialization of these inventions. And they usually follow very standard policies in terms of how they are willing to grant licenses to their IP and inventions. And very often, those agreements that they enter into with any company who wants to take a license to those inventions based on standard templates. So once a company or a founder or anybody has identified some invention or patent right of interest that they'd like to bring into their company, whether it's the foundational initial building block of the technology for the entire company, or whether later in the company's life cycle, maybe there's just new inventions or new IP out there that someone has noticed that could be of value to the company in continuing to build. So sometimes a company or a person becomes aware of new IP or new technology simply by virtue of reading papers, following institutions on social media, reading their websites that list all of the available patents and inventions for licensing. But very often, knowledge of a new invention or something potentially commercializable comes from relationships within the principal investigators at the research institution. And maybe that actually is you. You might actually be the PI of your own invention and wanting to use your invention to spin out and start up your own company. But in any event, all of that IP is owned by the institution and needs to be licensed from the institution. So once you've identified the IP, the invention, the technology, the data, whatever it is that you'd like to use, you need to hire a lawyer. And the reason why is for the same that what we've been talking about for the last 45 minutes, which is legal representation at this early stage is going to be crucial to avoid mistakes that can come back and bite you later. So you get a lawyer, and ideally somebody who has experience in licensing and even better in licensing with universities, because that type of licensing arrangement can be very different from licensing and exchanging intellectual property with a private company. And once you have legal representation, you will connect with the tech transfer office of the university or the research institute. A non-disclosure agreement is going to be the next order of business, and that's going to protect both you in terms of what you're sharing with the tech transfer office. You may already have confidential information about your company, your product roadmap, your ideas for development, and it protects the tech transfer office to the extent that there is confidential information within coming out of the university that's not yet been disclosed, perhaps in a patent filing. So a mutual non-disclosure agreement is going to be the key document to enable the conversations with TTO. I will say in terms of interacting with your technology transfer office and the officer, it's really important to establish an open and transparent and honest relationship with your tech transfer officer from the beginning so that you can establish a level of trust and a level of kind of amicability, because you're going to be working with this person very closely. And in some ways, they will be the gatekeeper to your company of access to the technology. So I encourage you, as with all your business dealings, to always act with a level of, a degree of professionalism and respect. And establishing that relationship early will really help you as negotiations progress, because sometimes negotiations can be tricky. The other thing I'll mention is when you're thinking about the license agreement and the terms of the agreement, which we'll get into in a moment, not only must you consider these terms in light of where you are with your company and where you want to be with your company with respect to this technology, but you need to think about the critical stakeholders and your future relationships. And so we heard this from Brian and Mark, that you are going to be having conversations with investors down the road. So and also, at least in my world, you will likely also have conversations with pharma or other collaborators down the road too. Any company perhaps that will have the resource and investment opportunities to help your business grow. So the license agreement that you sign today with just you and your co-founders and maybe a consultant is going to be the license agreement that you have to live with tomorrow. And it's going to be the license agreement that your investors are going to scrutinize. And it might even be the license agreement that your pharma collaborator will have to inherit. And most university tech transfer offices know that, and they'll know that when your lawyer is asking for provisions in the license agreement that might not seem exactly on point for a nascent company with like very little money, they do understand that this is the license agreement that you're going to be living with, and there are future stakeholders who are going to have a very different perspective on the terms. And the last thing I'll mention is that it is sometimes the case that when licensing IP from a university, you might also wish to establish a continued relationship with the inventor of that IP, because that lab or that group of inventors and scientists might be coming up with more improvements and iterations on this IP, and they might be looking for funding to do all of that. And so a nice way to access future IP and improvements to licensed IP is to enter into sponsored research agreements with the university with whom you already have a license. But as the name implies, sponsored research means you have to pay. So sometimes it's not feasible to sponsor research with the lab, but sometimes that's something that you can kind of get to down the road. Next slide. So when you are thinking about a license agreement with the university or with anyone else, there are going to be some key terms, kind of a basic structure that you should expect from any license agreement. The first question is, what is being licensed, right? What permission are you getting to practice intellectual property of somebody else? Is it patents? Is it patent applications? And yes, it is very common to take a license to a patent application for a couple of reasons. One is, well, certainly you need to have confidence that the claims in that application will actually issue, but assuming that you do have that kind of confidence, it's useful because it will allow you to be first to market. So there's a lot of advantage there. And it will also allow you to enforce the patent application once it's issued against past infringers. So I'm not the expert, Mark is, but if somebody out there is practicing the claims in a patent application free and clear, once that application issues, if the claims are the same, that person actually was infringing. So there's an advantage to being protected from that. You can license know-how or trade secrets, anything that is secret and provides economic value, software, as I mentioned, and data. Scope of the license, the question there is your license non-exclusive, meaning you are permitted to practice that IP, but so is everybody else, and that will be less expensive? Or is your license exclusive, meaning only you have been granted this permission? Sometimes the scope of the license can be, I guess corresponding to the scope of the license is the field of use or the indication. Is your license for all fields and all uses and applications and indications across the world for everything? Or will the university only grant you a license for the limited field of use for your company? Or perhaps the limited field of use for your initial research? So say this technology could be useful in oncology, but maybe it's also a treatment that could be useful in neurological disease. Ideally, your license will grant you rights to all indications, but it's very often the case that the university will only grant you a license to the indication for which you have demonstrated real and planned development. Licenses can also be territorially limited. So you will at least want a license for the entirety of the US, assuming you're operating in the US, but licenses can also be worldwide. And the territorial limitations may also have an impact on the fees and the cost of your license. Key terms that your licensor, the owner of the patents, the university in our hypothetical, will expect is to see your research and development plan and your business plan. So they want to make sure that if they're giving you a license, you're a legit company with real plans and you have a real roadmap, not only to development, but also to fundraising. Many universities will expect that you will have raised some amount of money by a certain period of time as part of what's called your diligence obligation, the obligation that you have to the university to actually succeed and advance the product. Of course, there will be financial terms, and we'll get into that next. And there will be term and termination provisions. So these are going to be like the basic terms of any license agreement. The financials, everybody's first question. So, we don't have a lot of time to dig into all of these, but I will mention these are the categories that you should expect to see from a typical university license agreement. Many universities will ask for equity, and we could spend, and I'm sure Brian too, could spend an entire hour talking about what that looks like and what's market and what's reasonable and what's unreasonable. Of course, that's all in the eye of the beholder, but suffice it to say that what things looked like 10 or 15 years ago and in terms of what you can expect from a university is gone. Universities and research institutions are all over the place these days in terms of the equity that they are asking for their startups. The other economics are real dollars. I will say that some universities, I don't know how many, sometimes only ask for equity and royalties and nothing else. And I would describe those as being more founder friendly. And oftentimes those are the terms that they are giving to their own inside founders. But then you can have economics on the far other end of the spectrum with very heavy real dollar commitments, such as upfront license fees. So some dollar amount that you pay right away. It could be as low as $1,000. It could be as high as $1 million. It depends on what the technology is and how far advanced it is. A lot of universities will ask for an annual license fee, basically a minimum amount that you have to pay every year just to keep your license, especially if your license is exclusive. And this is part of the ways that the university ensures that you're the right partner for them, and you're not going to basically squander this IP because you have real money on the line in the form of annual license fees. Once you start to advance the technology, they might expect that you pay milestones when you hit development milestones like filing IND, dosing a patient, drug approvals. They may also ask for payments once you hit commercialization milestones like first commercial sale and then thresholds as you increase sales. They will also ask for royalties, which is a percentage of your sale of the product. They may ask for minimum annual royalties, similar to your annual license fee. It's a minimum amount that they expect you to pay them every year to hang on to your license. If you sublicense your rights, for example, to a pharma partner down the road, the universities will expect to see a share of that. They may even ask to see a fee should you assign this agreement to a pharma partner, should you undergo a change of control, sell your company. There can be a host of other economic terms that universities might ask of you, and there is no one size fits all. They're all very different. Slide. And then royalties. So royalties are complicated. There are a lot of provisions in the license agreement that will move the needle on royalties, and you have to be very sophisticated to ensure that you are not paying longer than you need to or more than you need to. And I did see a note in the chat asking about licensing patents post-expiration or licensing know-how. So it is possible, it is likely that a licensor will ask for royalties following expiration of the patents, but only for a period of time. And in my first bullet point, you see here, for example, until at least you've been selling the product for something like 12 years. And that's usually to account for what Mark mentioned earlier, which is it takes so long to bring a product in life sciences to market that many of those patent years are lost, and the licensor still wants to recover royalties for those kind of lost years. And the way they do that is to ask for royalties for some period of time beyond. But in that other period of time, the royalty rate should drop. Slide. And then this last page, and so you'll see this, I think, when they shared the pitch or the deck, is additional licensing resources. There's a lot here, so definitely take advantage of the resources available to you.
Great. Thank you so much, Tali. There are a few questions in the Q&A that I might have you and Mark go and look at and see if you can answer since we are running short on time. And I do want to get to Matthew's slides now, but thank you so much for already answering that one question that you saw. So I'll pass it over to Matthew.
Yeah, thank you, everybody, and thank you, everybody that's still on. I get the privilege of being the anchor leg for today, so I'll try to bring it home. The legal topics that we've been covering so far are essentially table stakes, and the fundraise is really a separate business-centric problem, and that's really what I want to tackle for the next couple of minutes. I want to talk about the document that sits at the center of every fundraise, and that's really your investor pitch deck. And specifically, I want to cover what the pitch deck actually is, what it has to do, and where it most often fails. So if you're drafting one now or you're about to, you should be able to take what I'm about to cover and stress test your own deck against it tonight. So let's start with the reframe, because I think most first-time founders get this fundamentally wrong. And so here's the reframe. Investors don't actually read pitch decks, they're screening them. And what that means in practice is really this. A partner, or more often a junior associate at a venture fund, sees dozens of decks in a given week, sometimes more. And they're not sitting down with your deck and a cup of coffee to understand your company. They're scrolling through it on their phone between meetings. And they're really looking for a reason to say no. And you should understand very clearly that that's their default position, is to say no. And so something really has to stand out in your deck to get past the default. And the truth is you have very little time to actually change that default position, about 90 seconds really. And so in those 90 seconds, this reviewer is not forming a nuanced view of your science or your specific investment opportunity. Fundamentally, they're running a pattern match exercise against 4 fundamental questions. And so if your deck answers all 4 of these questions cleanly, you've earned basically a shot at a meeting, most likely with the same associate who's screening opportunities for their investment committee. And if your deck answers or fails to answer any one of them, the deck's going to get closed. And if you get a reply, it's going to be a polite no, often with no explanation of why you were passed over. And so this is really the single most important thing to internalize about how your deck gets consumed. Your audience is not a careful reader. They're a screener, and your deck has to pass the screen before it ever gets a read. And so that reality really shapes everything that I'm going to say that follows. Next slide, please. So if the deck is being screened and not read, then the next question is screened for what? And what is the deck actually trying to do? It has 3 jobs, and these 3 things happen in sequence. The first job is to get a meeting. This is the cold intro, the warm intro, the conference follow-up. You send the deck or someone's going to send it for you, and it has to earn a first call without you in the room. And this is the 90-second screen that I just spoke about. If the deck doesn't clear this far, nothing else really matters. The second job is to survive the forward. And this is the part that most first-time founders don't think about. You take the first meeting, you think it goes well, and you're happy. Now the partner or associate you met with has to sell the opportunity internally to their colleagues or their investment committee, or to the partner whose sector expertise covers your space. They forward your deck, and at that point, your deck is being read by someone you've never met at 9 o'clock at night on a phone with no one there to explain it. And if it only makes sense when you're the one narrating it, you've lost. And so job 3 is to anchor diligence. And once an investor is actually interested in you, your deck becomes the reference document for everything else that follows. The data room gets measured against it. The financial model gets measured against it. The reference calls get measured against it. If your deck overclaims in screening mode, you pay for it in diligence. If it underclaims, you may never get to diligence at all. And so the deck has 3 jobs in one document, and in every one of them, the deck is being screened against the same 4 questions. And that's what I want to talk about next. Next slide, please. And so here's the framework. Every investor pitch deck, regardless of the company, regardless of the sector, regardless of the stage, has to answer 4 questions. And importantly, it has to answer them from the investor's perspective, not from yours. Here are the questions. Why now? Why this? Why you? And why invest? And that's really it, 4 questions. And the order of the questions matter because it tracks how an investor actually thinks about a new opportunity. Why now comes first because if the timing isn't right, nothing else matters. You can have the best science and the best team in the world, but if the market isn't ready or the regulatory path isn't open or the capital isn't flowing, you're too early or you're too late. Why this comes second because once the timing is right, the investor needs to understand what specifically you're doing about it. What's the problem? What's your approach? And what makes your approach defensible? Why you comes third because once the investor believes the opportunity exists and your approach is sound, they need to believe this is the team to build it. And why invest comes fourth because only after the first questions are answered affirmatively does the deal itself matter. Terms, milestones, use of proceeds, the commercial conversation only happens if you've already cleared the first 3 bars. Now here's the diagnostic use of the framework. If your deck fails to answer any of these 4 questions cleanly, you're going to know. The feedback will come in the form of meetings that never convert, questions that keep circling back to the same issue, and investors who seem interested but never move forward. The framework tells you where your deck is failing before an investor articulates it for you. And so for the next 2 slides, I'm going to walk you through how the traditional pitch deck elements map onto these 4 questions, starting with what is typically in the first half of your deck. For the next slide, thank you. The front half of your deck has to do one thing. It convinces the reader or the screener that a real opportunity exists and that your answer is the right one. First question is why now? This is essentially the operating environment. So you're not just describing your company here, you're describing the conditions that make your company possible right now in a way it wouldn't have been 5 years ago. That's the tailwind. It might be scientific, a new modality has become tractable, it might be regulatory, a new pathway has opened or an old one has closed, or it might be competitive. Incumbents have gotten complacent or a category leader has stumbled. But whatever it is, the why now slide establishes that this window is open and you're walking through it. Why this? This is your investment thesis. And this is where most founders spend most of their energy because it's the closest to what they actually do every day. Unmet medical needs, scientific rationale, development path, commercial pull-through, defensibility. These are the slides that answer the question of all the things you could be working on, why this, and why this specific approach to it. Strong why this content doesn't just explain what you're doing, it explains why your approach is defensible against the adjacent dozen teams working on something similar. And here's the test for the first half of your deck. A partner or associate should be able to read the first half of your deck on their own without you explaining it and come away with a very clear view of the opportunity in your approach. If they can't, the front half of your deck isn't working yet, and more science is not going to fix it, and neither is a slick design treatment. Next slide, please. So the back half of your deck has to do 2 things. First, it proves you can execute, and second, it defines the deal itself. Why you? This is the team and traction. So this is where the investor asks whether this particular team is the right team to build this particular company. Founding team and domain expertise, execution history, advisors, consultant, members of your board of directors, company milestones that have been achieved to date. The bullets on this slide look like a list of content categories, but they all roll up into one question in the investor's mind. Does this team have the credibility and the capability to convert my capital into meaningful progress? If the answer is yes, you've earned serious consideration. But if the answer is no, or it's unclear, the rest of your deck won't rescue you. Why invest? The deal and the return. This is the commercial conversation. How much you're raising, at what structure, against what milestones, with what path to the next round, and eventually, hopefully, to an exit. At the stage most of you are likely at, which I think to be pre-seed through maybe Series A, the financial picture is directional, not definitive. And really no investor expects a 5-year revenue model to be right at this point. What they expect is that the numbers make internal sense and that the use of proceeds map to specific milestones. And those milestones are the one that de-risk your next round. Your financial story is a plan for how this round's capital becomes the next round's credibility. So here's what I see most often. The front half of the deck gets weeks of attention, and the back half of the deck gets a weekend. Founders polish the problem slide until it gleams and then throw the ask slide together the night before the meeting. And that imbalance of attention is visible to investors, and it tells them something unflattering, that you've thought really hard about what you want to build and not nearly as hard about the deal you're asking them to accept. Strong back half content of your deck is what separates an interesting idea from a company that's fundable. Have the next slide. So in my experience reviewing decks, one common mistake shows up again and again inside each of these 4 questions. And if you can avoid these 4, you're way ahead of the game. The most common why now mistake is what I call the invisible trigger. You describe a large market, you gesture at a tailwind, but you never name the specific thing that changed. Could be a regulatory decision, an enabling technology, a reimbursement shift, or a cost curve that changed. Without a name trigger, your why now collapses into why not 5 years ago. And that's not a reason for investors to invest today. The most common why this mistake is the problem and solution, but no wedge. The problem is real, the science is novel, but there's no defensible reason that your approach wins against the adjacent dozen teams doing something similar. Differentiation gets asserted, but rarely demonstrated. The investor reads 2 slides of novelty, and the question in their head is, versus what? You have to answer that question explicitly on the slide in writing. You don't get to answer it later because you might not be in that meeting at all. The most common why you mistake is the team slide that reads like a roster. Names, titles, prior companies, headshots is really a directory. It's not an argument. What investors are screening for is whether this team holds an insight earned from lived experience that separates them from the rest of the field. Essentially, what makes this team uniquely positioned to build this company, as opposed to generally qualified to build any company. And when a team slide answers that, it becomes the strongest page in the entire deck. The most common why invest mistake is a use of proceeds disconnected from value inflection. If you tell me you're raising $5 million for 18 months of runway, you've told me nothing. Runway is a duration. It's not a destination. Now, if you tell me you're raising $5 million to reach a specific readout, a regulatory filing, a specific commercial signal that de-risks your next round, now I know what I'm buying, and now I can see the path. Runway is not a milestone, de-risking is. So there's 4 questions, 4 common mistakes. If your deck clears all 4, you'll pass that 90-second screen I alluded to, and if it doesn't, you're going to know where you're failing. Next slide. So that's the framework many investors are quietly using to screen your pitch decks. 4 questions every investor silently asking, and 4 mistakes that I see common to be inside each one. So whether you're about to raise or you're in the middle of one now, this is the diagnostic I would suggest you run before your next investor meeting. And if you're working on an investor deck and want a second set of eyes, my contact information is here or will be shared after, and I'd be happy to have a conversation. Thank you.
Great. Thanks so much, Matthew. That was fantastic. So we'll go to the next slide just to show everyone. We do have the contact information for all of our panelists here. So if you do want to contact them afterwards, there you go. We're going to take the slides down now and have all of our panelists come back to us. For the last 11 minutes or so, we're going to answer a bunch of questions that you have still are remaining in the open Q&A, and also that were sent in ahead of time. And so, Mark, I'm going to start with you. A question on expenses. IP expenses can be very large and grow quickly. How do you build both an early IP fence and be economical?
Yeah, it's a really good question. It's one of the chicken and the egg questions for a lot of startups is you often need IP patents to raise money and and you need money to pay for patents. So I think it can be helpful if you're with a university or an organization to start with your in-house people and like I said earlier, talk to your attorneys and try to understand the most efficient way to develop your technology and the most efficient filing plan for your patents. And then from there, you're just going to have to figure out how to pay for it or to find, a lot of firms, I believe Wilson does, I know Mintz does, will have in some cases, under appropriate circumstances, startup packages, if the circumstances fit, doesn't fit for everybody, and there's requirements because there's a lot of risk. But really, I think you've got to have a good, efficient plan on the front end and just have some candid discussions with your attorneys and professionals, and then look for the best way to get a good patent at the best price you can handle.
Thanks, Mark. Brian, a similar question to you about budgets and what founders should have in mind regarding those initial expenses that they're going to have for incorporation, employee contracts, et cetera, and what options exist that you know of to keep those costs low, considering the financial limitations of startup companies.
Sure. Yeah, so Wilson Sonsini and I think other firms that are, familiar with and kind of designed to work with startup companies have thought about this problem. And we at Wilson offer a fixed fee formation package that basically includes all of the documentation, all of the process around incorporating a startup and getting its foundation ready and issuing equity to founders, basically everything I talked about in my presentation. So we do that for a fixed fee of a few grand. And we also have other packages like a fee deferral package to kind of well qualified clients and a corporate subscription package where we kind of do work on an ongoing basis until your first or second financing for a fixed fee per month. So that gives startups some kind of predictability when it comes to your legal spend.
Great. Thank you, Brian. Tolly, we have a number of questions still on licensing left. I'm not surprised. So happy to also ask you about the fee question as well, but I would like to also get to some more of these questions about licensing. Can you define, first of all, in licensing and out licensing and what those mean for a company?
In licensing means you're bringing something in. Out licensing means you're sending something out. That's it.
Great. And then, we talked a little bit about know-how. You mentioned that during your presentation. How does financial consideration around know-how typically work? Is it royalty? Is it flat fee? Is there a preference for one or the other? And if so, why?
Well, oftentimes know-how is licensed in connection or in conjunction with patents. And if that's true, then the value of the know-how isn't so important because presumably the patents are the driver of the value. But if you're licensing know-how on its own, I would caution you. Number one, know-how is only valuable if it's secret. So some know-how can rise to the level of trade secret. It's secret and it gives you derive independent economic value from it. In other words, if you know that secret, then you have an advantage over the company that doesn't have that trade secret. Typically, trade secrets don't garner as much of a compensation back to the owner. It could be royalties. It can come in any form or flavor. It depends on the trade secret, and it depends on how the trade secret is being used. And I put in my chat, you have to have a lot of caution there because you want to make sure that your agreement is written very carefully, that if you're paying someone a royalty based on products developed using trade secrets, that it's very clear as to what those products are, because you can unintentionally obligate your company to pay royalties on much more than what you're imagining. You're going to have to be very careful in showing that the specific trade secret was used for this very specific product, so you can tie a very clear line from the know-how or trade secrets to the product, and that you're not kind of bleeding into your whole company with royalties. And you should only also be paying for as long as it remains a trade secret. So if you've paid for it and you've gotten it, it's been a secret, great. But then if the university publishes on it next year, you shouldn't be stuck paying royalties when the rest of the world isn't.
Right. Absolutely. Got to be on par with everyone else.
Mm-hmm.
Matthew, question to you. I loved your slide that said kind of like, here are the mistakes you often see when people make with each one of those questions. What do you see usually as the biggest mistake that people are making in their decks, either in their decks or when they are pitching to investors?
There's so many, but the one that drives me really crazy is burying the ask. I'll see preliminary pitch decks. I'll go through 10, 15 slides of science, and it's still not clear to me what kind of money they're trying to raise and why. And
And
so
why do
I
you think
think
that happens so much?
um, with academic founders primarily, I think there's just this tremendous familiarity and excitement with the science that they feel like that's the element of the deck that is the strongest, and certainly the one that they're most passionate about. They're less familiar with the commercial elements of it and aspects of it. So I guess just as a bias, you kind of lead with what you're excited about and what the strength is. But I would say you've really got to be very clear with what you're asking investors up front. They may not have the patience to page through 5 science slides that are very dense and read more like a poster presentation at your latest academic conference than a pitch deck. You've really got to distill that science into why an investor should care and recognize that you're dealing with a very different stakeholder audience than you typically do when you're starting to work with institutional investors. So I would say that that's a common one. The other one that I see a lot is this disconnect between the capital you're asking for and what that actually buys. I see a lot of pitch decks that will talk about raising a $5 million seed round, and they talk about it in terms of that buys me 18 months of runway. And as I said in my slide presentation, that doesn't really tell the investor anything about what their money's getting them. The investors are trying to calibrate $5 million against what that means in terms of the company's increased its value by a certain multiple, or it's brought its program farther along and it's now de-risked to some certain degree, or it opens up an exit opportunity or a partnership. Investors need to see that, and they need to feel what the magnitude of that opportunity is in real dollar terms. And I think a lot of founders really miss those two things.
Great advice. Thank you. Mark, we got through an almost entire webinar without talking about AI. Amazing, huh?
Yeah.
Especially right now. But I'm going to ask you a question because one had come in beforehand. In tech startups developing proprietary AI tools, what are the trade-offs between filing patents early versus waiting until the technology is more mature? So how can you basically protect the IP effectively without overcommitting resources at the start,
Yeah, I mean,
especially in AI?
yeah, in AI, it's moving so fast. So I hope this answers the question. It's moving fast, and there are a lot of people active, and we just don't know who's doing what. So there's a increased pressure to file your patents sooner in AI rather than waiting because so many are coming along, and you just don't know. You won't know for 18 months after they file who grabbed which piece of land. So I'm finding that most people are trying to file as soon as they can, and then supplementing those filings as they go forward is kind of the best approach I'm seeing right now. And really important with AI to engage with an attorney because there's a lot of complicated issues around software and machine learning and all those kinds of things. So it's a hot area. And right now, I would say what I'm seeing mostly is people are filing fast and early and often.
Okay, great. Thank you. Brian, we have a number of institutions that we work with, startups that we work with, et cetera, that are technology originally outside of the US. So, for example, if they're a Canadian-based original startup with a US market, where would you advise they incorporate?
So it all depends. I mean, we do have a number of contacts with Canadian companies, and there are particular tax advantages for folks to incorporate in Canada, and their Canadian investors get tax benefits there. So often we see Canadian kind of technology put into a Canadian domiciled startup. Um, when they come to the US and start selling here or have employees here, then we talk about dropping a subsidiary in the US. So that's a whole conversation. And sometimes, it'll be the case that investors will want to invest into a Delaware entity, like I was talking about in my presentation. So in startups, we'll be talking about doing a flip, an inversion into the United States entity, and that has tax complications tied to it. So that's a whole conversation. But generally speaking, startups have to kind of make their own decisions about what makes sense for them at the outset, whether that's their local jurisdiction or starting out in the US if they're targeting kind of a US investor base.
Great. Thank you, Brian. We are at time. I'm going to ask you each for 10 seconds to say what is your number one piece of advice to a startup founder, how to work best with their attorney firms. Mark, I will start with you.
Just communicate. Don't hesitate to reach out. Be candid, be open, and just communicate your needs and both in terms of price and cost and those things, and just have an open, candid conversation.
Great. Thanks. Matthew.
Do it right the first time.
All right. Great. Brian.
Yeah, that's mine too. Get it right the first time and don't be too afraid of the costs. Like we'll always work with you on the costs to get everything right. We're aligned with you when it comes to kind of building a valuable, enduring enterprise and getting your technology out onto the market.
Great. Thanks, Brian. Tali, your piece of advice.
I'll just say the same thing, penny wise or pound foolish.
Yeah. Great. Well, thank you all so much. I appreciate all the work that you put into this. This was fantastic advice. We could have gone on obviously far longer, but I hope this was a really good foundation for a lot of new founders out of academia about how to work with attorney firms in their initial stages. So thank you all so much. Thank you to our audience for being here today, and everyone enjoy the rest of your day.